And we're live. Folks, welcome to this week's Lawfare Live. I'm Benjamin Wittes, editor-in-chief of Lawfare, here in the blazing sunlight studio. I'm joined by Roger Parloff in the Sconce studio, Quinta Jurecic in the Ansel Adams studio,
Hello.
James Pearce in the Cathedral studio. Is that what we're calling it, James?
I like it. Let's
Uh,
do it.
all right, the Cathedral Studio. And we are soon to be joined by Anna Bower, who is dashing out of court as we speak. Guys, we have a Supreme Court opinion, which Roger and Quinta are feverishly reading. We're going to deal with that second so that they have a chance between the two of them to read 24 pages. In the meantime, James and I are going to talk about the Supreme Court's completely fascinating oral argument in the birthright citizenship case yesterday, which was not an argument about birthright citizenship. It was an argument about nationwide injunctions, aka universal injunctions. And I thought it was fascinating, James, how diverse the headlines on this were. Everything from government takes a beating, Trump administration solicitor general takes a beating, to justices seem sympathetic to Trump administration on universal injunctions. Um, what did you make of it? And do you think there are tea leaves to read here?
Yeah, I thought it was a fascinating argument, and it doesn't surprise me at all. And I've seen some of the reporting that you also mentioned that suggests kind of all sorts of different readouts of the argument that we heard. A couple of observations, some of which have been widely reported. I found it very interesting that there was relatively no discussion of the underlying merits of the birthright citizenship question, and the handful of times that it came up, there were things like Justice Kagan saying, assume that you are dead wrong on the underlying merits. What does that mean for the universal injunction question? And there weren't even, at least if there were, I missed it, and I think I listened to all of the argument. Any of the justices raising, who might be at least somewhat sympathetic, raising kind of counter arguments. Now, that's not entirely surprising, as you said, Ben, and as what as best as we could understand going into an argument with no question presented. What was teed up here was this universal injunction question. I do think that the John Sauer, the Solicitor General, faced more skepticism. I won't say outright hostility, but more skepticism for his position than I had anticipated. There are some justices, I think Justice Gorsuch among them, who seem to have been often quite outspoken in their dislike of universal injunctions generally. But yesterday at the argument, just to pause on Justice Gorsuch for a moment, I took him to be engaged in a pretty thoughtful effort to try to parse when, under what sorts of circumstances, the kind of broader relief that you see it in a universal or nationwide injunction would be appropriate. In particular, he had a couple of exchanges with the Solicitor General of New Jersey, who I have to say I thought just did an absolutely
Fabulous
fantastic job. Yeah, one of the best.
I'd never heard him argue before, but you know, talk about the art of meeting every justice where they are and engaging with them incredibly respectfully, with a point to make to each of them that, engages their own writing. I thought it was a particularly artful oral argument. And, for those who want a kind of master class in the art of oral arguments, this was high up there in my book.
I couldn't agree more. I think he was helped a little bit by the fact that, as he quite articulately and artfully said, he could kind of straddle both lines. In this particular case, of course, he was one of those seeking the universal injunction, but recognized that, look, as a representative of a state, he was on behalf of New Jersey, but of course also representing, I think, the 22 other states, and maybe more than that. I may be confusing that with some of the other state-based litigation, but that they also had concerns of under certain circumstances, broad-reaching universal injunctions that is going to tie their hands. And so, but yeah, I thought to go back to the point, so he set out, he being Jeremy Feigenbaum, as someone put in the chat, the New Jersey Solicitor General kind of set out these different categories of cases where a universal relief or universal injunction would be appropriate. And Justice Gorsuch engaged with him in a way that suggested, look, I'm not, as a bright line rule, I'm not interested in the government's position, which, as I understood it, was essentially, to the extent there is ever an opportunity or it's ever appropriate for there to be broader relief than just the parties before the court. In fact, it wouldn't really be that, because it'd be through class action, and that would mean that those parties are before the court. And I didn't really hear anybody signing on to that. Even Justice Alito was raising practical problems with that, Justice Kavanaugh as well. And so I think some people have commented, and I agree, that to the extent the court is really just interested on the universal injunction issue, this was a pretty poor vehicle to sort of suss that out, because I didn't see a lot of the justices suggesting anything other than, yeah, this is the type of case where such relief would be warranted. I think the other interesting thing, or an other interesting thing out of the argument, were the number of justices that seemed interested in potentially getting to the merits. They all seem to agree that it wasn't teed up now, neither the parties nor the justices. But again, Justice Gorsuch, I think, asked a couple of times to more than one advocate, how can we expeditiously get to the merits here and resolve this question? The answers were essentially things like supplemental briefing, and you could set this for argument soon. And I heard Amy Howe on a podcast of SCOTUS blog suggesting her prediction was the court was going to do that and move quickly to merits briefing. They haven't done that yet, at least as far as I've seen, although we just, of course, saw them act in AARP. So they are a busy court, as we know. But yeah, I think it'll be interesting to see. For what it's worth, my prediction, you asked about tea leaves, is that the court is not going to try to get to the merits now, at least before the end of the term. And I don't think they're going to come out with some sort of bright line rule about universal injunctions always bad. I don't think no one ever thought they were going to say always good. I do think, and I frankly think it will be a good thing, that they try to articulate some guidance about the scenarios or the circumstances in which it would be appropriate and it would not. Justice Gorsuch, a couple of times when advocates kind of proposed that path, said, well, we've been doing that, and the district courts aren't getting it right. But I think if that's really the focus of the analysis here, that can kind of reset the playing field for the district court judges for whom this comes, and then maybe there's some more clarity moving forward. But
yeah, so
that's my read.
Yeah, so let me bounce my read off you and see if you see what part of it you take issue with. First of all, it seems to me that that the states, at least, and the states had a much better argument than the individual plaintiffs did, in my view. But they made some headway with Alito too, and the evidence of that was that Alito seemed to me quite frustrated with Sauer, the Solicitor General, in the sense that he kept saying to him, "Hey, wait a minute. If you can just refile this case as a class, and doesn't Rule 22 effectively recreate the exact same issue simply by having a class of everybody who's affected by this?" And Sauer couldn't really say no. He also couldn't really say yes, because he doesn't want to acknowledge that in fact a class would be certifiable. But I think if I were Sam Alito, I would have walked away from that argument with, wait a minute, what do we even get by restricting the universal injunction here? They're just going to come back with a class that we're going to have to certify, because actually it is cognizable as a class to say everybody who's affected by this, irrespective of other considerations, can be part of the same class. I mean, you're going to get some huge percentage of the people involved in that class at some level. So, what do we really win by reining in, the universal injunction component if you're merely going to recreate it by other means? And then you get to Gorsuch saying, well, I didn't really mean all bad. And by the way, I love your three-part categorization, and you clearly fit into exception number one. I just want some help in figuring out how to tell district judges be more careful with this. And so I actually thought, oh, and then Amy Coney Barrett sounded like she was nowhere in where the government would want her to be. And so I left it feeling like, you know, they had made some real progress on at least three. I didn't get a good read of where either Kavanaugh or the chief was, but on at least three, they didn't seem to be where they should be for the iron wall of the conservatives to line up. How much what am I missing there?
So I would sign on to a lot of that. I think a lot of that's right. I would, I suppose, with some caution, offer some predictions with Kavanaugh and with the chief that will go in different directions. Which is, I think the points you made about Alito pointing out the problems with class actions strikes me as accurate, and certainly a bit of a surprise, because you might have thought he would be more sympathetic to the position the government was advancing. And I believe I recall, I think Kavanaugh was quiet during all of Sauer's sort of free time, but then when it came to the seriatim, I think Kavanaugh jumped in with a bunch of questions similar to the kinds of criticism or concerns that Justice Alito had raised, and at some point said, like, look, we got, if we say it's got to all be class actions, all these class action suits are being teed up right now, and they're going to start flooding into the courts, and we're going to have to deal with this, and so will all of the kind of associated problems. So from that, I sort of took that Kavanaugh is not as much in the government's camp as the government certainly would hope and would need to prevail. By contrast, the chief was, I think, relatively quiet, which isn't so unusual for him. I think he has often kind of good questions, but is not as talkative as a lot of the other justices. But at some point, he sort of tossed the softball to Sauer, saying something like, so this depends on us being able to act expeditiously, and certainly we can do that. We, the Supreme Court, we did that in TikTok, I think he gave as an example. And I imagine he would probably point to a lot of the work that the court is now doing on their emergency docket, shadow docket, whatever people want to call this, including the opinion that or the order opinion that we'll talk about next in AARP. So I took that to be a little more skepticism with the position of the challengers. In other words, a little bit more favorable to the government. But yeah, I agree. There's not a lot of data to draw from there. The other interesting thing, I also agree with you with Barrett. I think it's probably worth just touching on. Lots of reporting has indicated, sort of has focused on this as well. But Barrett really pressed, sort of Barrett and Kagan together really pressed Sauer on this notion of, so you'll respect a Supreme Court decision, but not so clear you're going to respect if there's the Second Circuit reaches
Right.
this.
The Second Circuit doesn't mean you have to not do any stuff in New York.
Right. Right. And so I think that was a telling moment. Yeah, I think there's been some commentary suggesting at least Sauer, the Supreme Court got Sauer to say, yeah, we will respect the court. Now, whether Sauer speaks for the government as a whole and the administration as a whole there, of course he does formally. If he does in practical terms, time will tell. But I thought that was an interesting exchange. And the fact that Barrett was pressing on him, I think also points to some generalized skepticism with the government. And I think underlying this, and perhaps what we'll talk about next in AARP, though I say this with having looked at it for all of 3 minutes, and I'm sure Roger and Quinta will have much more insightful things to say, which is a point that Quinta has been making in some of her work on lawfare, and Alan Rosenstein as well, which is like this, erosion of presumption of regularity questions, right? Is this really still the 10th justice, the Solicitor General before the court? Do we have faith that the government is going to act in good faith with sort of the way we expect it to? So obviously not an explicit issue teed up as part of this case, but I certainly saw that as a theme running through the argument from a wider spectrum of justices than one might have expected.
All right, before we go on to AARP, I want to ask about the three liberals because it seems to me that they seem to be sketching out quite different approaches to this. And I want to specifically highlight the difference between Ketanji Brown Jackson and Elena Kagan on this. Kagan sounded very much like Amy Coney Barrett to me. And Ketanji Brown Jackson seemed to be going in a different direction, which was, hey, there's nothing wrong with universal injunctions at all. It's not a question of reigning in the injunction. The issue in the injunction is you're telling the defendant to stop doing the thing that you're finding unlawful. And the fact that it's universal is merely a collateral benefit to non-parties. But you're actually, as a court, only addressing a party to the specific litigation. So there's something unexceptional about that at all. Sonia Sotomayor, meanwhile, seemed to be suggesting that the problem here is the magnitude of the wrongdoing, that the issue is there are, I mean, she kept emphasizing you're violating the law as stated in 4 Supreme Court opinions, none of which have been overturned, the apparent plain text of the Constitution, and a federal statute. And, you know, when do we get to say that's illegal? And Kagan raised a very specific concern that wait a minute, if you disallow the universal injunction, you're never going to appeal these. You're going to lose at lots of different appeals courts, and you're just not going to appeal it because you only recognize the nationwide implications of a Supreme Court and since you're going to lose, you're the one who has to appeal and you're just not going to do it. And she was applying a kind of very realpolitik uh, uh, litigation strategy. I've never heard actually a Supreme Court justice discuss the litigation strategy of the federal government with the Solicitor General before. It seems to me these are three very different perspectives, and we group the liberals in together, but I'm not sure they're coming down in the same place, or at least their reasoning seems different. What do you think?
Uh, so I think a lot of what you said again is spot on. I have a couple of reactions just to what you said, and then what that might mean, right? And I'll go sort of in the opposite order with Justice Kagan. At one point, she said something like, "If I were in your shoes, I wouldn't bring this case to our court." Now, she has been in his shoes, of course. She was the
She
Solicitor
was the
General
Solicitor General.
for a hot minute or two before joining the court. But and again, it was sort of I think some insight into her thinking on the merits of the case, which is not particularly surprising. With Justice Sotomayor, you're right. I mean, it was interesting. She did seem to suggest, look, if something is so terribly, terribly, and obviously unconstitutional, and not only did she, as you say, sort of cite the 4 cases and a long history of practice, she also tried to flip the kind of political valence of the issue when she kept talking about, imagine taking away everybody's guns, and a president who comes in and says, because of gun violence, we're stripping everybody of their guns. Could there be nothing that this court could do about it here? And so, think about this if the shoe were on the other foot. So Kagan being in your shoes, lots of shoe metaphors. Justice Jackson, yeah, as Justice Jackson in her time on the bench has shown, she's often kind of coming at this from a different angle that other justices aren't. I had sort of a hard time following exactly what she was driving at, but it was an interesting idea. And then kind of taking them together, I got the impression, which is not a surprise, that each of the 4 liberal justices were expecting they were going to be having to fight to try to sort of pick apart why a bright line rule doesn't make sense. And so they were coming with different reasons why it doesn't. It just turned out that they were in greater company than they expected. Now, I think Justice Kagan is a tremendously capable strategist on the court, and I imagine that she, working with some others, will craft something that will perhaps kind of address the concerns that the three liberals indicated, or sort of articulated, along with the other justices that seem to have skepticism about a broad position. What that will look like, I'm not sure. Maybe it's something like the three buckets we talked about earlier. But I don't. I took those sort of different ways of coming at it to be kind of different ways of kind of preparing defensively, even though the terrain turned out to not to need that kind of defensive strategy once we started to hear where the other justices were.
Interesting. Just to clarify what I think Justice Ketanji Brown Jackson was getting at. I think her point was, okay, Sauer is arguing you can't give relief that goes beyond the specific defendants and the specific plaintiffs, i.e., the litigation is between two parties. There's only an Article 3 case or controversy between those parties. Yes, I acknowledge sometimes relief will have collateral benefits to other people, but a universal injunction always goes beyond the specific parties in question and thus is an Article 3 problem. And I think what Ketanji Brown Jackson is saying is, wait a minute, not so fast. If Ben is suing James and Ben is the federal government and the relief James asks is make the federal government stop doing this illegal thing, then the relief that the universal injunction is simply the relief that James needs, i.e., federal government stop doing that illegal thing. And it has this collateral benefit for everybody else, but it's not actually an injunction that goes beyond the two parties. Neil Gorsuch and Sam Alito are not going to sign on to that, but it's an interesting maximalist argument that I hadn't seen the others making, and it's certainly not what New Jersey is asking for.
I agree with all of that. Yep.
All right. With that, we have sucked up 23 minutes of your time, which has given Roger and Quinta the ability to read 24 pages, which is more than one page a minute. And as a result, we can now talk to you about AARP. Quinta, get us started. Remind us which case AARP is and what question was before the Supreme Court before we get to how they disposed of it.
Well, I should say to start off that some of the pages don't have a lot on them, so we were actually reading more slowly than that. AARP is the case in the Northern District of Texas that has actually since had its case title changed, thanks to a request from the American Association of Retired Persons. So at least in the district court, it is now, I believe, WMM. But at the Supreme Court, for some reason, that did not percolate up. So it is still AARP, that being the initials of one of the plaintiffs.
And just to annoy the actual AARP, I think we should call the case American Associations for Retired Persons v. Trump, just to be nudniks. No, I'm joking. We're going to call it AARP because that's what the Supreme Court is calling it. But it is not, as the retired persons pound the table and tell us, it is not the Medicare lobby.
Yes, this is someone's initials, so AARP or WMM, whichever you choose. So this case, if listeners remember, comes out of the flurry of activity from a couple of weeks ago or a month ago, maybe, where a district court in the Northern District of Texas had denied a motion for a temporary restraining order to prevent the removal of a class of Venezuelan detainees to be removed to SECOT, the El Salvadoran facility under the Alien Enemies Act. The ACLU then immediately appealed to both the Fifth Circuit and I believe simultaneously filed a petition to the Supreme Court. The Supreme Court ended up stepping in before the Fifth Circuit. The justices blocked the government from removing anyone. The Fifth Circuit then came in behind them, saying that they would have denied the motion from the ACLU, but because we had that Supreme Court block, no one was able to be removed in the Northern District of Texas. That's important because a couple of days ago, the judge in this same case, so now WMM, I will say he acted very expeditiously to change the case title, less expeditiously in the actual issues of the case, once again denied a class certification. And so this was concerning, and I will say there's a great piece from Lee Kowarski and Theodore Rave in Lawfare that just went up the other day explaining the issues here in much more detail than I can give here. But the long and the short of it is that that meant that anybody who was potentially removable under the Alien Enemies Act and was in the Northern District of Texas, that stay from the Supreme Court was the only thing that was preventing them from being removed. And so there was this danger that it was kind of creating an incentive for the government to basically funnel everybody into these facilities in that district to so that, you know, when the court acted, they could potentially just remove everyone very, very quickly to El Salvador. So now the Supreme Court has stepped in the wake of that district court, this denial of class certification, and said, no, actually, this is just for a putative class in the Northern District of Texas. You do not get to remove people, or at the very least, you don't get to remove people without some minimal level of process. So this is a per curiam ruling. The per curiam is pretty clear, saying we're not weighing in on the substantive issue of whether the Alien Enemies Act was properly invoked here, whether you can remove people under the Alien Enemies Act. What we're doing is we're actually going to send this back down to the Fifth Circuit to weigh in on what the appropriate sort of level of notice and process is for these detainees who are potentially removable to SICOT. And that is important because one of the games that the government has been trying to play is building on the Supreme Court's previous ruling in JGG, which said that, I forget the exact wording, but that detainees were mandated to have some sort of level of adequate notice in order to file a habeas petition. The government kind of took that and was doing, I mean, not even the bare minimum, like laughable levels of quote unquote notice, you know, handing out forms that weren't in Spanish or were only in English and not in any other languages, offering 24 hours or less to actually go to a court. And so what the per curiam is saying here is that is absolutely not sufficient. But we're going to send you back down to the Fifth Circuit to figure out what actually would be sufficient here. And in the meantime, you can't remove anybody. I will say there's kind of a funny note at the end where when the court is setting out precisely sort of the procedural steps going forward, it specifically says there's a specific clause in there that says, and by the way, this order that we're putting in, this block, is going to stay in place until we decide what to do with your petition for a writ of certiorari from the Fifth Circuit, which we kind of assume that you're going to file. And then they say, or maybe you won't file it. But they're building that in there, I think, because they're assuming this is going to come back to them again. That this was my very preliminary take that I developed while I was reading as I was listening with one ear to you both. So, Roger, I'm very interested in your thoughts, and please correct me if I got anything wrong.
I didn't hear anything wrong. I think it's being remanded for two purposes. To decide, you might have said this, also to decide if the Alien Enemy Act is properly invoked, as well as the due process question. So the two questions. There's a little bit devoted. It's surprising in a short decision, and then how much is devoted to sort of petty stuff here, which is like if you remember, this was the case where, NBC, you've seen the NBC footage of the buses being loaded at Bluebonnet and heading for the airport. And, James Hendricks would not rule, the judge in Northern District. And so eventually, and what he was saying was, uh, I need to provide the government with 24 hours to respond before I will make any ruling. So eventually they went up without him. And so there's a dispute here. And the first time around, Alito with Thomas had dissented and said, they only gave the judge 42 minutes. And so the majority is saying, no, they gave him more than 14 hours. And a lot of this is back and forth. So all of that is petty and has no relevance at all. By the way, in a footnote, it makes clear that Judge Hendricks's ruling on the class certification is vacated automatically. That's just because they granted cert. That happens. So that's sort of officially out of the picture. Kavanaugh then concurs, and if I read it, and we all read this really fast, so we're all making mistakes probably. But Kavanaugh, as I get it, he would have just not even sent it back to the Fifth. He would have asked for more briefing and just decided these issues, which is interesting that only got or it didn't get 5 votes. I mean, I think that I would have thought, or 4 votes, I guess, or I don't know how many you would need to grant. I think you would need 4 to grant on that issue. But anyway, that's what he would have done, and then the rest of it was Alito's dissent with Thomas joining and defending himself about the 42 minutes. And then there's a hyper technical argument that if James, once James reads it, he can weigh in on, but about whether there's an appeal from what the Fifth Circuit did, which was to not. It was a weird posture when the Fifth Circuit last got it, and they were saying they didn't have jurisdiction, so maybe. So Alito is saying we don't have jurisdiction. I'll leave it there.
So to either of you who wants to take it, what is really, other than the incidental litigation history of this matter, what's really the dispute between the dissenters and the majority?
I mean, sorry, go ahead.
Oh, I'm sorry, go ahead.
I mean, one way to put it, to go back to the point that James was making earlier in your discussion of the birthright citizenship / nationwide injunctions case, is just, do we trust the government or not? I think that, one way to kind of read the Alito dissent is he's really saying, well, why would this district judge have needed to move quickly? The government said that they weren't planning to do anything, which maybe sounds very convincing if, you've lived under a rock and just lifted it up, right?
Or if you were appointed by George W. Bush, who never misrepresented to a court what who never said to the court, we're not going to do X, and then turn around and did it, but is completely naive if you're dealing with this administration.
Right, exactly. It's very specific to the conduct of this administration. And then there's this really striking passage in the per curiam, which, thank you to Brad Heath of Reuters for pointing this out on Blue Sky, where the per curiam ruling says, we recognize the government has agreed to forego removing the named petitioners pursuant to the AAA while their habeas proceedings are pending. We reject the proposition that a class action defendant may defeat class treatment if it is otherwise proper by promising as a matter of grace to treat named plaintiffs differently. I think that the sort of the matter of grace note there is very telling, that they're basically saying, come on, perhaps unlike Justice Alito, we do not live under a rock, and we can see exactly what you're doing. And I do agree with Roger that this sort of back and forth of like defending versus attacking Judge Hendricks's honor is just very odd. Um, but it is true that reading the sort of parallel accounts of what happened in the timeline is telling in terms of what is emphasized and not emphasized, and the version in the per curiam is just way more skeptical of what it is that the government is saying, whereas Alito is sort of taking that at face value in a way that I think clearly or seemingly 7 other justices were just not willing to do.
All right. So, Roger, for those who did not follow this, the twists and turns here, where does this leave things? It goes back to the Fifth Circuit, kind of to announce what a process is going to be.
To decide two things. To decide is the Alien Enemies Act can you invoke the Alien Enemies Act in this situation? You know, is there a predatory incursion? Is there an invasion? Is there a foreign state or government? They're going to decide that, and then if there is, if the AEA is properly invoked, then what process is due in the first instance?
And do
So
they say why they're going to send that to an appellate court to decide in the first instance? I mean, usually you remand that kind of thing to the district court.
Well,
This is the part where the honor of Judge Hendricks is maybe important.
No, I think it's a pretty standard part. So the Supreme Court will send it back to the Fifth Circuit. I think the Fifth Circuit, the parties may even agree that the Fifth Circuit ought to send it back to the district court. It's standard procedure that it goes back to the Court of Appeals, and then the Court of Appeals can decide whether they, in the first instance, should decide the question or kick it further on down the line.
I just want
to. It really doesn't sound that way in the way this is written to me. I think that, you know, he's had his shot, Hendricks. We know what he's going to do. I think they're saying, Fifth Circuit, you decide these two things. I mean, he's better qualified than me, but that's how I read it.
I mean, I'm looking at the disposition on the final page of the per curiam, and that language is all pretty standard, including, I think, Quinta, you mentioned the language about, like, you know, we keep this in place pending a writ of cert, even whether it's filed. That's also pretty standard language that you'll see on their emergency docket. So, you know, I haven't read enough to kind of see the back and forth over the district court judge. But I do think it's this part, the sort of the disposition is pretty much kind of run of the mill. Whatever differing justices may feel about the bona fides of the district court judge here, and it will be up to the Fifth Circuit. I mean, the Fifth Circuit will get it. It may or may not ask the parties, should we decide this in the first instance, or does this need to go back to the district court for the district court to take a crack at it? I think that would probably be the right and would be the standard procedure, but that can be a question that's sort of worked out between the parties and the Fifth Circuit.
I guess I just want to point out that if memory serves about Boumediene, Justice Kennedy's opinion ends with, you know, we leave these questions in the good hands of the district court in the first instance. He doesn't kick it back to the DC Circuit. Now, maybe that's because it's on the standard docket, not on the emergency docket. But I do think there's something. I don't know. I've never seen the Supreme Court kick a question back to the appellate court that the district court hasn't ruled on yet. I don't know.
Well, he has ruled on these. Not, it's a weird posture. He has in fact ruled on these.
All right. I stand corrected. I'm just saying it reads weird to me. Not that I've read it. Anna Bower, fresh out of court in the blue cushion studio, with the weird colored walls. Where are you?
This is the Crown Plaza Hotel studio next to the Greenbelt Courthouse studio.
Excellent. It's great to see you. It kind of looks like a Crown Plaza. I hope they have like good like beer.
Yeah, I
Anyway,
haven't tried the beer yet, but maybe after we're done
right.
recording then, because it was a long hearing.
All right. So you were in Judge Siniz's courtroom until a few minutes ago in the Abrego Garcia case. First of all, remind everybody which one the Abrego Garcia case is, because it's been a couple weeks since we've talked about Mr. Abrego Garcia's. And what's the status and what were they talking about in court today?
Yeah, Kilmar Abrego Garcia is the Maryland man who was wrongfully removed from the United States to El Salvador. This is the case in which Judge Sines originally ordered that the government effectuate his return to the United States. It then went to the Supreme Court, who said, facilitate his release and treat his case as if he had not been removed from the United States. And it went back down. She amended her order to say facilitate his return. And then the government proceeded to do apparently nothing, it seems. And so as a result, Judge Sines allowed discovery, the plaintiff some discovery around three different questions. One is, what steps have you taken to facilitate his return? What is the status, his custodial status? And then, what steps in the future might the government be willing to take or plan to take to comply with the court's order to facilitate his return. Lurking in the background of all of this is this question of whether or not the government is complying with the court's order. And so we're in this discovery process still that at one point was put on pause for reasons that remain unclear, because a lot of these filings are actually being done under seal. So some of this has been a little bit hard to follow, Ben, because as you're trying to follow the docket, it's like the government's filing things under seal. So are the plaintiffs in some cases. So it's not entirely clear what exactly is happening, but the context of today's proceeding is that plaintiffs were able to depose three people who previously filed declarations in the case. Those were kind of lower level to mid-level, people from DHS, from state. Although one was the general, I believe one is the general counsel, or I can't recall if it's like acting general counsel or what the official title is, but of DHS. But regardless, they were able to depose some people, and the plaintiffs were able to submit interrogatories that they got responses to. But ultimately, the plaintiffs have claimed that they were being stonewalled in all of these responses. The government, in terms of producing documents, was invoking many privileges, including a deliberative process privilege and state secrets privilege. The same in these responses to the interrogatories. And then when it came to the depositions, again, we don't have the content of those because they aren't on the public docket, but we do know some things about them based on what claims the plaintiffs have made. And then today in the hearing, people have made about the content of those depositions. And it sounds like they basically didn't get much from the deponents. It was a lot of, I don't know, I don't have personal knowledge. So as a result, the plaintiffs filed a motion to compel additional discovery. They also requested a discovery conference to hash out some of these issues regarding these invocations of privilege related to state secrets and deliberative process privilege. So Judge Sines set this hearing for today. The main topic of the discussion was not so much, the question of whether they should be allowed to have these additional deponents, but more so on what the next steps are in terms of figuring out the state secrets privilege issues and the deliberative process privilege issues. And so she mainly discussed that with the parties. Who was arguing on behalf of DOJ is a guy named Jonathan Gwynn. And and our known quantity, Drew Ensign, was not there for the government today. It was Jonathan Gwynn. And, Ben, even though we were supposed to be talking about these, legal issues of state secrets and deliberative process, and eventually it got there, a lot of this hearing was kind of just Judge Sini's arguing with DOJ about like very basic questions around like whether or not they have even provided any information in compliance with the court's order, because DOJ continues to say, oh, like the government has given the plaintiffs all the information that they need, and Judge Sini's kept saying, well, I don't think you have. And so kind of there's a lot of back and forth about that. And then on the legal issues, Judge Sini is really focused on the state secrets for much of the hearing. One of the issues there is this question of whether or not the government has supplied sufficient evidence to show that national security or diplomatic relations would be endangered by the disclosure of this evidence in which they're over which they're claiming state secrets privilege. As a part of, making that showing, the government did supply an affidavit from Marco Rubio. I believe that this affidavit, it might be public now because during the hearing she ordered it made public, but at the time of the hearing, it was still under seal. But from what she announced from the bench, it sounds like it was very similar to an affidavit that Rubio filed in the JGG case that was public. And it sounds as though, based on what Judge Sini's observed, it sounds as though it's very conclusory, doesn't really provide much kind of concrete reasons as to why there would be this kind of blanket invocation of state secrets about a lot of misinformation. And so she was kind of trying to get the government to give her anything more, really, that it might be willing to, in terms of, would you commit to getting more, filing a supplemental affidavit, that kind of thing. The government said it would take it under advisement and work on maybe getting some more information, because she was very clear that she doesn't think at this stage the government has made a sufficient showing of, there being a real danger to national security or diplomatic relations. And then there was, even beyond that question, which I will say the plaintiffs were not enthusiastic about giving the government a second bite of the apple of allowing, them to supplement. They kind of were like, this is just allowing them to string this along even further. We've seen time and time again, they're delaying for delay's sake. But Judge Sini's, I think, wants to give them a very short window to maybe get some more there.
Because she wants to create a record, or she seems to have genuine doubt as to whether they are trying in good faith. What do you think she's thinking?
No, it's very clear to me that she feels they're not acting in good faith. That's all of the subtext of this entire hearing. And even at one point she said, like, I can't believe you're sitting here telling me that the government is acting in good faith. But I think that she at one point went on a kind of monologue about how she takes her role as a person who is a co-equal branch of government very seriously. And because she was making it very pointed, right? Of like, I take my job as a member of the judicial branch seriously. And that's why I'm, going to give you this opportunity. Because she said, we have other things to work out in the meantime anyway. So I'm going to give you one more shot to kind of give me some more meat on the bone of the state secrets privilege stuff. But, even beyond that question of, supplementing the affidavit, she focused as well on this question of like, well, what if in a case where intent is in question, which in her view, intent is in question here because it's, there's a question of whether or not the government is acting in bad faith and complying with her order. Is there some kind of way in which, like, even if there is a kind of, maybe it's unclear if there's a showing of danger, then do you go on to look at the need and then decide, maybe I need to look at these documents that you're claiming state secrets for in camera and decide if, based on that, like maybe there's more probing if you can't meet that kind of very minimal threshold of the judge I don't remember the language in the case law, but it's like the judge has to satisfy herself that there is reasonable or a real danger to diplomatic relations. And so I think that she's thinking maybe at some point it might be necessary to do some kind of in-camera review if necessary. And also that, there might be a kind of more of a balancing of the equities at that stage than you might usually have in a state secrets case, where there's typically like a significant amount of deference, but a lot of the other conversation around the state secrets issue focused too on, fact that this doesn't involve classified documents. One new fact that we learned, I think it's new, is that the arrangements between El Salvador and the U.S. were previously classified, but apparently that has changed according to DOJ.
Have they now been disclosed?
So there's a lot. So it's again, Ben, it's really hard. A lot of these conversations, we're talking about things that we just don't understand or know what they're, because they would jump around to talk about things like,
right, they're talking about a complete record, but we don't have a complete record.
Right, we don't have it. And then they would stop midstream and say, Your Honor, I think this is better in a sealed session. And then the judge would say, okay, well, I'm going to put that on the list for the sealed session. And then they had like a list of things that they almost got into or they hinted at getting into, but then they ended up leaving it for a sealed session that happened after this long marathon hearing. Beyond the state secrets issue, there's also the deliberative process privilege issue. And that was, not as significant of a portion of the hearing, but it led to one of the more interesting parts of the hearing, or dramatic, I should say, parts of the hearing, because in the course of talking about the deliberative process privilege, the plaintiffs have argued that there's this exception. There is an exception. They haven't argued there's an exception. There is an exception that they say applies. It basically is that, if there's a showing of governmental misconduct, then this exception doesn't apply. They've also made an argument about this other exception called the compelling need exception. But in the course of this conversation about government misconduct, the government starts talking about, because the plaintiff's argument is like, since the very beginning, this has been a case about government misconduct, go all the way back to the circumstances of his removal. You have the government admitting that he was wrongfully detained at that wrongfully removed at that very first hearing, and that there, wasn't a basis even for his detention and then removal to El Salvador, all of this stuff. And as in response, DOJ, is discussing this question about whether or not those original circumstances of his removal constitute some kind of it could imply or suggest government misconduct over the whole case. And remember that the question around whether he was wrongfully removed to El Salvador is what led to Arez Ravini's firing, and some of the admissions that he made in that first hearing is what led him to be fired. And then Stephen Miller went on TV and claimed that there's a DOJ attorney who's a radical Democrat who was sabotaging the case, kind of thing. And as we're getting into this subject, the attorney for DOJ, Gwynn, will not admit that during that first hearing and during that first initial phase of the case, the government conceded that he was unlawfully detained and removed. And he, at one point, the judge said, well, what about that first hearing with Mr. Ravini? He said this, he said that. There's the ICE agent Cerna who said this, and he said, and in response, Gwen says, "Well, Your Honor, I can't speak to what happened on that during that first hearing." And she said, "Come on, you took over this case. I know you've read the transcripts."
Not to mention that the Supreme Court has made as a finding of fact that that the government has conceded this. So it's the law of the case whether he wants to admit it or not.
Right. And then it was one of the most awkward silences I've ever seen in court, to be honest. It was this very long, drawn out pause in which he just went completely silent and didn't say anything. And it was very uncomfortable. And he eventually, when he did speak up again, he said that he would assume, for the sake of argument, that he had been, unlawfully detained and removed, and then, kind of went from there using the hypothetical, saying, "Oh, but even that doesn't show, government misconduct, even if that's the case." So it was a really kind of astonishing, is in the back of his mind. I assume in the back of his mind is the fact that his colleagues had been, fired for conceding what he was being asked to admit that the government had conceded. So that was quite an interesting moment. On the deliberative process privilege stuff, again, Judge Sines does not seem to believe that the government has met its burden of, showing why the privilege should apply. She did seem into this government misconduct argument, and then also to the compelling need exception argument. She over and over again, noted that this is a qualified privilege, that, there's a balancing of equities and factors here. And then the way it ended is basically she didn't rule from the bench. There's a lot of nitty gritty details that the parties wanted to get into in terms of discovery matters that they couldn't speak on publicly. And so she basically just kind of said, "All right, let's get into the rest of this in a closed session," sent everyone on their way. And here I am at the Crown Plaza Hotel after it was quite a long hearing, about 3.5 hours.
All right.
2.5 hours, excuse me, 2.5.
We have 30 minutes. There have been no questions so far, which is convenient because this is when we turn off the questions. And so we're going to use this last half hour of the show today to do a speed through all the other cases. We've used the first 60 minutes of the show to go through 3 cases, and we're going to go through all the rest in the second 30 minutes because, we get to prioritize. So I'm just going to do this in the order in which it's in the document here. Quinta, let's start with tariffs. There's been this VOS selections case on the tariffs. What's going on with that?
There was oral argument this week in this case, VOS Selections, which is challenging the IEEPA tariffs. They kept referring to them during oral argument as the Liberation Day tariffs, which both sides actually, which I thought was a nice touch, and specifically challenging them on the grounds that the president had indicated that the trade deficit was a national emergency that was such that he was able to invoke AIPA to impose these tariffs. So there
And
are,
just to be clear, Quinta, that's pronounced AIPA.
yes. Um, Every time I say it, I think that. So there are a range of arguments here. So the plaintiffs are arguing that AIPA, the text of AIPA, doesn't allow the imposition of tariffs. Even if it does, the president has to make a formal declaration of emergency, which he hasn't done. And even if he did that, the trade deficit is not emergency under the terms of the statute. I have to say it was an interesting argument to listen to, in part because I've never listened to an argument at the Court of International Trade before. It was very collegial. They closed by thanking the work of all of the court staff who had, made the hearing possible, which I thought was very sweet. But more on the subject at hand, I think what really came across to me was that the judges, this is a three-judge panel, were just really struggling with how to define a standard for on this question of emergency and what constitutes an emergency. They really pushed counsel for the plaintiffs on how they would identify that line. To the point where the counsel said at one point that he was asking the court to be an umpire and call a strike. That's a direct quote. And that in this instance, the pitch was so far outside the zone that, they didn't need to be specific about, did it graze the edge of, I forget what it's called, the strike box, whatever it is. This pitch was totally wide. I will say the judges didn't seem super convinced by that and did keep pushing to try to identify a judicially manageable standard. Then, of course, when counsel for the government came in and made a range of arguments, but among them that the existence of an emergency is a political question and that the judiciary cannot weigh in. And that did seem to rankle the panel a bit. So I think at the end of the day, it is not super obvious to me what way the court will come down. They didn't seem super comfortable with being asked to determine the contours of emergency, but they also really did not like the suggestion that the judiciary should butt out here. So we will see what happens. I think it's anyone's guess.
This is the first case ever in the U.S. Court of Federal Trade to be discussed on lawfare.
They did seem somewhat bewildered by how many people were apparently in the gallery.
It's just, every now and then the light of the sun burns into obscure places. All right, Anna, let's talk frog embryos case. It's taken a really dark turn.
Yeah, it has taken a dark turn. There was a hearing earlier this week in the case of, is it Ksenia? Yes, okay. It's Ksenia.
Yeah,
Petrova,
but pronounce it as one consonant, Ksenia. There's no Ksenia. It's just, there's no vowel.
Ksenia.
Yeah.
All right, thank you. So this is the Harvard scientist who is from Russia, who was on a J-1 visa, brought from France some clawed frog embryos. I can't
as one does.
It's a case that is very much not funny, but unfortunately I can't help but laugh every time I have to say clawed frog embryos. But
I've never seen a clawed frog. I just want to say frogs don't have claws. And so there's the whole clawed frog embryo raises the.
Yeah. Are there unclawed frogs?
Are there unclawed frogs? What is a clawed frog?
I don't know. Ben, you were asking some of the same questions the judge, you and the judge both want to know. But there's
sorry, I think there's one other question, is whether a clawed frog gets along with a witoad.
Yeah, so there was a hearing in the case of the clawed frog embryo detention. Cinia has been transferred to Louisiana. She's been in detention for about 3 months now. And the circumstances of this case are a little bit like procedurally, it's like at a bit of a weird place because initially her counsel filed a habeas petition that made like a bunch of like requests for relief that fit with the facts that they thought they were at the time, because the government said there was an order for her removal. It turns out there wasn't. So they had asked, for various things related to their belief about what they thought the facts were on the ground. In addition to the habeas claim, they, made some APA type claims in this petition. So then after the judge sets a habeas kind of initial hearing, the government files a motion to dismiss for lack of jurisdiction. We get to this hearing that the judge is kind of like, I don't really know, like what you guys wanted me to really deal with today. Like, are we dealing with everything or just the motion to dismiss? They end up discussing the motion to dismiss. I think what the judge took it under advisement, but I think what she seems to be struggling with is, this question of like the weirdness of how the petition as it was filed originally fits with what they kind of seem to want now, which is her release. And she has said that she will go back to France willingly because that's where she, was traveling from. But the issue is just that she doesn't want to go back to Russia because of past political persecution there. So it's a case that has a lot of complicated facts and has a bit of a weird posture. And for the sake of this lightning round, I'm going to speed through it and just say the end result in terms of that hearing is that judge took the motion to dismiss under advisement and set a hearing or said that there would be a hearing within the next few weeks for a bail hearing. The very next few hours, pass, same day as this hearing taking place where the judge says, I'm going to set a bail hearing. Hours later, she is then the subject of a criminal complaint filed by the Justice Department for smuggling under 18 USC 545. The smuggling of the alleged smuggling of clawed frog embryos. Again, earlier in the day during this hearing, there were a lot of questions about like, wouldn't this usually be a fine? This is something that you're not criminally, and you have something that is of that nature of what she had, you're fined as opposed to prosecuted. That said, there are some facts in the complaint that which was sworn out, by the way. The supporting affidavit was sworn out like 3 months after the incident. But regardless, as alleged, there are some facts in the complaint that I think are not like great facts for her if they turn out to be true. They relate to text message that she sent in which people were asking her, well, what are you going to do about customs? You need to get permissions for the frog samples. But again, I plan to do some research in the next coming week about exactly how the law would apply to something like this, because I'm just not sure. But if anyone else has thoughts, then please chime in.
All right. So, Anna, you're breaking up a little bit. So I'm going to ask.
Oh, sorry.
Yeah, no, it's okay. We just got some background noise and some interference, I think, from the storm that's passing over. But give us a very quick Rameza Ozturk update, because that's in your department too.
Yeah, there was also a hearing this week about whether she'll be subject to ICE conditions during her release. She was previously released. This is the tough student who was taken off the streets in Somerville by mass immigration authorities. After her release, ICE wanted her to be subject to a bunch of conditions, travel restrictions, notification, registration, all this kind of stuff. There was a dispute over this. The parties didn't want any restrictions, the plaintiffs didn't want any restrictions. ICE, of course, wanted all the restrictions. The judge presiding over the habeas proceedings had a hearing to sort it all out. Ultimately, Ozturk will be subject to some conditions, but a lot of it will go through the enforcement mechanism or if ICE wants to enforce an alleged violation of it, there will be a 48-hour, notification to the court, to the judge in Vermont, who then, there will be a chance to respond. So he still kind of has some kind of oversight over some of these restrictions. And he ended up striking a number of the requested restrictions as well. So those proceedings are ongoing. He mentioned potentially having the habeas hearing around September. There's also a potential preliminary injunction forthcoming surrounding some of the issues that Ozturk was having with her CVIS records being deleted or otherwise just removed from the system. That's been an issue we talked about before. It's very loud, so apologies. I'm going to stop talking before it gets even louder at the Crown Plaza. Who knew that?
Hey, it's a
Crown Plaza
happening
Hotel in
place.
Greenbelt.
The Greenbelt Crown Plaza, where everybody goes on a Friday evening for happy hour. All right, we're going to speed through these initials cases. We'll start with James. CHNV and the national TPS issue, both at the Supreme Court. What are we talking about here, James? I literally have no idea what this refers to.
Yeah, so CHNV is not actually an initial. It stands for 4 countries: Cuba, Haiti, Nicaragua, and Venezuela. These are 2 cases that are
we're deporting whole countries now?
these are cases. I mean, sort of seems like it. Yes, where the Secretary of Homeland Security, Kristi Noem, in April, essentially canceled temporary protected status. That's the TPS case for a large tranche of Venezuelans, and in a separate case, or a separate administrative action, canceled protected status, not the formal TPS program, but protected status for the CHNV large group of Cubans, Haitians, Nicaraguans, and Venezuelans, more than 500,000. Those individuals and organizations representing both of those groups filed challenges in the district court. The district court, in both instances, granted relief, preliminary injunctions. The government sought stays pending appeal in both cases. The Court of Appeals, I believe they both came up through the Ninth Circuit, denied those. And so, as has often been the wont of the current administration, the Solicitor General has sought Supreme Court intervention, seeking a stay of the relief granted to the challengers. The very basic kind of dispute here is that the government says, look, this is entirely a discretionary call for the Secretary of Homeland Security. The statute itself says that in the Secretary's discretion, she can or cannot provide that relief. Here, the challengers are saying they're due sort of case-by-case relief. That's in fact not an accurate reading of the statute. Challengers come back in and offer a different statutory reading, I should say, as is typical of a lot of government litigation in this space. They also claim that there shouldn't be, so both under the INA and for other reasons, the district court has no sort of cause to be adjudicating these cases at all. So it's up at the Supreme Court. The TPS case, that is just Venezuelans, is fully briefed, awaiting Supreme Court action. The other case, the CHNV, we got the government response just within the last few days. I assume we'll see a reply. I imagine the court will dispose of these together. I don't have a great read on what the court will do, but when they act, we will let folks know.
All right. Before we turn to the initials cases, James, let's talk for a moment about Judge Hannah Dugan, who in Milwaukee, who has now been indicted and has moved to dismiss. You have, she's dismissed on an immunity claim, which is a matter on which you have some expertise. So bring us up to speed.
Yeah, so as you said, she was indicted. This is a judge we've talked about a few weeks ago. I had a piece in Lawfare kind of looking at her criminal complaint. She's been indicted now for a misdemeanor count of concealing someone with a arrest warrant and then obstruction. The day after her indictment, somewhat unusually quickly, she filed a motion that basically says she is immune from criminal prosecution because the indictment rests on official judicial acts. And the first case that she cites is Trump v. United States, the case of the former president, which
Zing!
With which I did have some involvement. I don't think that this motion is going to fly. In fact, in that Trump litigation, though this didn't form a significant part, or really any of the Supreme Court's analysis, there was a lot of discussion of immunity from criminal prosecution for prosecutors, judges, other officials, and the short version is it doesn't exist, criminal immunity, and in fact, that is the judge overseeing the case out of Massachusetts that we've talked about before that has facts that were quite similar to Judge Dugan, the district court judge there, also rejected a motion to dismiss on judicial immunity grounds. I think that's probably the right result here. You can imagine a judge who accepts a bribe in exchange for doing something that everyone would agree is a core judicial official act, right? Ruling in a case, sentencing someone to a more favorable sentence. But we'll see. The government hasn't filed its response yet. There's also, I should say, a portion of that motion to dismiss that seems to suggest that there's some kind of a 10th Amendment or federalism type problem, which is an odd argument, essentially saying that the federal government has sort of invaded the prerogative of the state of Wisconsin. That's also not really a thing, though I understand, I think, the rhetorical reasons perhaps behind making that point in these times.
All right. Thank you. Roger, let's turn to Gutierrez Contreras. So for each of these, I'm going to name them and remind us what the issue in these cases is and where it is, and then give us a brief rundown.
Gutierrez Contreras is a one-off habeas in the Central District of California, Riverside, and judge somebody's subject to a Venezuelan that could be subject to the AEA proclamation, and the judge, Sunshine Sykes,
Great name.
Ruled that he gets at least 14 days notice before he can be removed. He actually has already been somehow, I don't exactly get these facts, but he's moved out of that district and he's in Bluebonnet in the Northern District right now. But it's only it was never a class action, so it's not that, we don't know how much it means.
It's precisely the way in the case, no national injunctions, they want everything litigated this way, right? Yeah. Everybody's case affects only the two parties in front of them.
Yeah.
All right. Next one, JGG.
That's the granddaddy of them all. This was but at this point, it's an attempt to bring a class action for the people that were already shipped to Sakat on March 15th under the AEA. And Judge Boasberg today ordered some limited jurisdictional discovery, meaning discovery that will be relevant to whether the U.S. has constructive jurisdiction over those prisoners. So it's going to raise a lot of the same questions that are live in Abrego Garcia. And I honestly, I think the plaintiffs did not really want to ask for it, but Judge Boasberg sort of hinted he'd feel better if they did. And so we're going through that there.
Badar Khan Suri.
He is the postdoc. He's an Indian postdoc at Georgetown. And he was released from detention. He had been in detention in Prairieville, Texas. His wife is a U.S. citizen, but she spent a lot of time in Gaza, and her father was apparently a government official there at some point. So people were saying he has ties to Hamas, and that is apparently was the basis for his visa being pulled. But so this is he at least gets out of detention for now. That's based on the First and Fifth Amendments, but he'll have to continue. This is in the Eastern District of Virginia, where the judge is Alexandria, and it's Judge Patricia Tolliver Giles.
ASR.
ASR is another Alien Enemies Act case in the Western District of Pennsylvania. This had been a class action, but at the TRO stage, this Judge Stephanie Haynes, and but she decertified the class earlier this week because the government says there's nobody else in that district anymore who is ripe for AEA treatment. And in fact, even the plaintiffs has again been moved to Bluebonnet. And she had actually ordered that he not be removed from the Western District of Pennsylvania at the TRO stage, but they moved him the day before the TRO. Anyway, she said that he gets at least 21 days before removal if they're going to try to remove him. And again, it's one of those one-offs at this point, so it doesn't seem to mean a lot.
All right. That brings us to the last one, MAPS. MAPS.
Yeah. That's in the Western District of Texas. That's a class-wide TRO against removals under the AEA. It was a very short order. He says there's a likelihood of success of showing that the proclamation violates the AEA and due process, but he didn't really explain his reasons. So at this point, there are 5 judicial districts where AEA is blocked: Southern Districts of New York, Southern District of Texas, Western District of Texas, District of Colorado, all because the judges there have said it's invalid, the AEA or the proclamation. And the Supreme Court has, as we know, has barred them from being removed from the Northern District of Texas.
All right. That covers the initials cases. James, we have 2 new impoundment suits. What's the deal?
Yeah, so in that red hot funding freeze district of Rhode Island, we had 2 complaints filed earlier this week. They must have been coordinated. They were filed on the same day. Illinois, along with 20 other states, against FEMA and DHS and a few other agencies was one. The other was California against the U.S. Department of Transportation. Both of the suits basically have the same kind of central claim, which is that the government has started, this administration has started to withhold funds from various important programs, disaster relief, that kind of thing. In the FEMA suit, in the DOT Department of Transportation case, various types of road safety, et cetera, and has conditioned funding. I'm about to lose power, so yeah, I may lose you, but has conditioned that funding on the states taking certain immigration actions. And the states essentially argue that that is either an unconstitutional condition or some kind of effort at commandeering, and then makes what we have seen as pretty typical in these cases, APA or claims directly under the Constitution. As I said, these were just filed I believe there are preliminary injunction motions out in each of them. So we'll see how that goes. But yes, add it to the list of additional funding freeze litigation, again, that seems to have really amassed in the District of Rhode Island.
All right. In the meantime, we don't have major developments on the law firm targeting issue, except one, which is that James, you and Natalie Orpett wrote a major piece on this this week that suggests that the law firms who settled may have a real problem or a set of real problems as a result of the settlements. Uh, uh, let's do a little bit of lawfare log rolling here and talk a little bit about this piece.
Yeah, so we just published it today, and there's been obviously a lot of reporting about the sort of the dynamic of the settling firms and the challenging firms, and a lot of, I think, quite fair criticism of the settling firms that, look, they just made this kind of crass business decision, and kind of moral criticism of that decision. What our piece tries to do is kind of do an analytical look at, is in fact their risk calculus a fair analysis of the risks that they currently face and could face. And so we walk through, potential risks, including, look, do the agreements trigger potential criminal liability under federal law as essentially a quid pro quo, a bribe in exchange for an official act, either rescinding in the case of Paul Weiss or foregoing an executive order in the case of the other firms. Under UK law, all of the firms have London offices. There's pretty broad reach of UK law. Could that come into play? Also looks at ethical considerations, civil law, potential liability, and we talk about both those risks that exist now based on the deals themselves, as well as the kind of slew of potential risks that may come with conflicts and other potential eventualities. So if this is a story that folks have been following and are interested in, that's a piece that's up on Lawfare this afternoon.
All right. Before we go to our final weekly update, James, there are two oral arguments involving agencies, one in Wilcox v. Harris, and one, you seem to be dismantling another federal agency. So what's going on with those two cases?
The DC Circuit was busy. These were both today in the morning. The court, not the same panel that had heard this at the motions, which was Judges Henderson, Millett, and Walker. This was now Judges Katsas, Walker, and Pan. And this is the case of what we sort of group as the Humphreys executor cases, the challenge by fired, removed members of the Merit Systems Protections Board and the National Labor Relations Board, basically challenging their firing. Argument was spirited and probably what one would have expected. There were, when the government got up first as the appellant, Judge Pan was really pressing the advocate about the kind of unitary executive theory, and in fact, the government advocate used the phrase that the executive is a unitary, energetic, kind of channeling Hamilton and Federalist 70. And Judge Pan had many questions, and then when the challengers sat down, and the governor came up, the sort of the dynamic flipped, and Judge Katsas had more questions. I have to say, Judge Katsas, though, had questions for both sides. I think he's probably still going to come down the same way that the emergency motions panel did, and probably find that the president has the power to remove these individuals. One thing worth noting, as folks may remember, the Supreme Court actually has administratively stayed the actual removals at this point. It's been sitting on their emergency docket.
Well, I think we have lost James. The storm finally got him. Which brings us to the last. I love the look on his face in that frozen shot. It brings us to the last question of the day, Anna Bower. Who is the administrator of Doge? Whoa,
The
maybe the
storm got
storm.
James, and then the Crown Plaza Hotel is like, oh, I was about to say the storm got James, and then the Crown Plaza Hotel is basically a storm in of itself. Um, I
It's
never knew
okay.
that things could be so lively here.
Look,
But so
if
who is the
people
administrator of Doge? The big
want highly produced stuff from a studio in 2 minute, sound bites, there's like you got MSNBC for that. We're bringing you Anna Bower fresh out of court, and she's coming to you from the Crown Plaza Hotel in Greenbelt. And if you don't
there's
like it,
like multiple children screaming in the back.
that's right. And James is, I could sing Somebody Got Lost in the Storm. Somebody got lost in the storm. And it was James. But Anna, the last question is for you.
So I know I'm cutting out too, so I'm just gonna say Amy Gleason might get deposed.
Whoa.
Whoa. So look, here's what happened in one of the FOIA cases regarding whether or not Doge is an agency subject to FOIA. This is the case before Judge Chris Cooper that was brought by Crew. Originally, Judge Cooper granted a limited discovery that included a deposition of Amy Gleason, the alleged acting administrator of Doge. The government then, challenged this, went up to the DC Circuit, tried to get a writ of mandamus. The discovery order was administratively stayed. And then just a few days ago, the DC Circuit, 3-judge panel lifted that stay and said, nope, the discovery order can go forward. And so Amy Gleason, we might get our first deposition of Amy Gleason. And that we have had 2 depositions previously of Doge people in other cases. Kendall Lindman was a 30B6 witness for Doge, but Amy Gleason, even though she's filed declarations, she has never been subject to, questioning about some of the statements and her role, herself. So that's a big deal. And we might just learn if she really is the administrator of Doge.
And if so, what that means. Does it involve any administration or administering? We're going to leave it there. Quinta Jurecic, James Pearce, who's back after having been swallowed by the lightning, Roger Parloff, Anna Bower, thank you all for joining us. You are all great Americans. Fact, we're going to be back next week because neither snow nor sleet nor hail can keep these analysts from their chosen paths of bringing you information